The Judicial Service Commission will advise President Cyril Ramaphosa that Deputy Chief Justice Mandisa Maya is suitable for appointment as Chief Justice. The President earlier this year nominated Maya for the position. She was the sole candidate interviewed by the Commission in a sitting yesterday. The incumbent, Chief Justice Raymond Zondo, is set to retire in August. Now, joining us to discuss the Deputy Chief Justice's interview and the JSC's decision is Freedom Under Law research consultant Chris Oxtoby. Good evening, Chris, and thank you very much for your time. So yesterday, the JSC announced its decision endorsing the Deputy Chief Justice for that position of Chief Justice. Firstly, your reaction as Freedom Under Law?
So I think it's very much expected. Justice Maya was a candidate for the position in 2022 when Justice Zondo was in fact appointed. She was then appointed as the Deputy Chief Justice. And as you say, she was in fact the only candidate for the position now. So this is no great surprise. She's been through the Judicial Service Commission process on several occasions. I think it's clear from the interview that she has an enormous job on her hands, and one can only wish her well with the task ahead of her.
Now that you speak of the enormous task ahead, there were some very worrying issues that the Deputy Chief Justice detailed, starting with the increased caseload. And she, of course, prefaced the concern with a statement of how much of an honor it is to serve in any role in the Concourt, but then went on to reveal that she has, however, never worked as hard as she's been working in the past 20 months. To receive almost or no less than 400 new applications for leave to appeal seems quite burdensome. What's your take on just what we heard yesterday about this?
Well, this is confirming an issue that has been in the public domain for a while. Viewers might recall at the beginning of the year, there was some controversy over a scheme that Chief Justice Zondo had introduced to try and use retired judges of the court just to help deal with that issue. So it's clearly become an enormous challenge for the court's functioning. Exactly what the root causes of that are, I think, is a question that still has to be fully answered. It's an issue that Freedom Under Law is currently researching. So I don't want to anticipate exactly what the circumstances of that of that is going to be, but it's clearly a fundamental challenge that the incoming Chief Justice is going to have to address.
But on that score of the use of retired judges, you are among those that raise concern that to have them beyond retirement serving in a core judicial function is quite problematic.
Yes, it was a concern that Freedom Under Law and other organizations did raise. I think one can understand the fact that a reform of some kind needed to be put in place, but the particular use of retired judges did raise institutional concerns about independence, and we certainly felt that there needed to be a better way of addressing that problem. And it seemed to be a position that the Chief Justice, in fact, accepted by indicating that the scheme had to be withdrawn. There were practical difficulties as well with the availability of some of those judges. So that wasn't the answer to the problem, but the problem, of course, still exists, and it will now fall on Justice Maya to try and address that. And there have been various suggestions that have been made. I think I get the sense that the leadership of the judiciary is still working out exactly what the best approach is going to be. There are a few options that have been spoken about. They include increasing the number of judges, splitting the court up into panels, and those, of course, also all bring some of their own potential problems with them. So I think it is very much ongoing.
Pardon me for interjecting there, but what would be the problems there? Because that was going to be my next question around the desirability of that specific suggestion of perhaps having smaller panels or the expansion of the bench itself.
So expansion of the bench, at the moment, as the law stands, all judges on the court have to sit and have to consider a case before the Constitutional Court. That already has been attributed as a cause for many of the problems that we're seeing at the moment, because it means that all 11 judges have to consider an application for leave to appeal, and that's simply impractical. Now, of course, if one increases the number of judges, that you're going to have to find some way of making sure that doesn't produce the same problem, just with a larger number of judges. If you start splitting the court up into panels, there are questions which, in fact, one of the commissioners raised during Justice Maya's interview about how you ensure consistency within the court if you have different panels of judges hearing different cases. Do you not run the risk that there may be some inconsistency in those circumstances? And it has been a criticism of the Supreme Court of Appeal, which sits in that kind of structure, that there has sometimes been inconsistency in some areas of law between different panels of the SCA. And the concern is that the court, of course, it is the highest court, and there is nowhere else to go once a case has been decided by it. So that would be the concern. I think we may well see a situation where perhaps the Constitution is amended to allow for smaller panels to consider leave to appeal applications only, but still a full complement of the court may hear the actual full substantive arguments on the merits. But that will be the kind of issue that lawmakers and judges are going to have to figure out in order to deal with the problem.
What a conundrum, Chris, because when listening to her detail that if perhaps they had session straight after a court hearing, maybe it would lead to them perhaps issuing the judgment a bit more timeously here. But then, as you state, if you've got 11 justices here, they all have to share their views, they must be interrogated. She spoke about divergence, and then at some point they must find each other to a certain extent. And as much as you may have dissenting views, but nevertheless, every single view of a justice must be interrogated. One thinks that it's basically a catch-22.
So one of the issues may be, and I think this is something that one still has to figure out exactly to what extent this is a part of the problem, but it has been a factor that people have suggested may be an issue, which is that the court's jurisdiction was expanded around 10 years ago. So the Constitutional Court, as the name suggests, used to deal purely with constitutional issues. There was then a change so that it had a more general jurisdiction. And certainly one of the concerns that was raised at the time was that this was likely to lead to a very significant increase in the court's workload. So intuitively, one would expect that, yes, this may well be a problem, and that the Constitutional Court is perhaps still using working practices that served it well when it was a court with a smaller caseload, or when it was dealing with more specialist constitutional-only cases, that gave it space for a more deliberative approach. And it is now perhaps simply faced with a workload that makes that impossible, and its procedures and rules have yet to catch up to that reality. As I say, it's something that I think is an important topic of ongoing research that ourselves, and I'm sure other organizations, are looking at, and no doubt the judiciary will be looking at as well, as to whether that is indeed the major factor that is going on here, or if there are other issues that are playing a role as well. But this is, as I say, certainly something that will need to be looked at.
Chris, thank you very much for your insights this evening. That's Freedom Under Law research consultant Chris Oxtoby. Quite interesting conversation there. And interestingly, that particular matter of having all and sundry access the Constitutional Court was hailed as a very progressive move, but it has come with a lot of problems now that we heard the Deputy Chief Justice speaking of the enormous caseload that they have to contend with. But most certainly a very interesting conversation.